T.G. Suresh, Chairman of IFA, has joined.
Good evening.
I think
we're also on YouTube today.
Yeah, they have done it. Originally, it was not planned. Subsequently, they have planned and
This is our first video on the YouTube, sir. From
Fantastic.
Yeah.
Wish you many more.
Thank you, sir.
But not at this COVID on something else.
No.
Let us have it on a regular this thing. See,
we are trying to, sir. We are trying to.
People are able to participate in a larger number.
Because some people raised apprehension about Zoom, so we thought YouTube also it will be there. So it's like right now about 21 people are on YouTube streaming, watching it live.
Oh, apart from Zoom, okay.
Yeah. Apart from this Zoom.
So we'll go online. Kishore?
Yes, sir.
We'll go online?
Yes, sir. We can start, sir. Very much.
Good evening to all of you. Good evening to Mr. Vaitishwaran, Speaker of the Day, Kishore, President of ACA, and other office bearers of ACA, Mr. Amit Nahar and Mr. Bharat, who are enabling this webinar by way of providing technical input, technology input. I'm very glad to welcome 74 participants so far. The participants are increasing moment by moment. Right now it is 75 participants who have joined to this webinar, jointly organized by Chartered Accountants Study Circle, Association of Chartered Accountants, Society of Auditors, and IFA region, Southern Region Chapter. And my hearty special welcome to Advocate Vaitishwaran, who has agreed to speak at the meeting on the very important topic of COVID-19 legal issues. This 25 days so far has never been part of this sort of arrangement in any of our professional activities so far. I have been in 30 years of practice, and Vaitishwaran is equally of the same age as far as legal practice is concerned. We have never had this sort of, I don't say it's a relaxing time, never a relaxing time, but all said and done, all of us are sitting as if we are jobless. But this fortunate technology advancement of Zoom or YouTube is making it possible to meet each other for discussing an important topic today, which is COVID-19 legal issues. The thought of having this meeting just clicked in the last MC meeting of CAC after Mr. Vaitishwaran shared a very good intellectual input on COVID legal issues by way of written mail, which we circulated to most of our members, not most of the members, all the members, and members asked us, why can't we arrange for a meeting itself so that we can have a interaction also, and Vaitishwaran will be able to spare time check up with them. After that, I checked up with the AC and other organizations who are also willing to readily join. So immediately we organized for the meeting. Thank you, Vaiti, for having readily agreed for this thing. We welcome you all. Vaitishwaran doesn't require an introduction because all of us know him. But for the formality's sake, let us just say a few words for those who are recently joining this group. Vaitishwaran has 3 decades of experience in legal area after having qualified in Madras Law College and started his practice in 1990 by joining a firm, Subbarayar Iyer, Padmanabhan and Ramamani office. He became a partner there in 1998. After that, he started his practice in 2000. And now he's having his office in Madras, Bangalore, and Delhi. He's practices on a wide range of subjects on all taxation, direct and indirect taxes, international laws, and now he's also very busy in IBC. And he has wide variety of clients, right from healthcare, manufacturing sector, information technology, hotels, hospitalities, etc. He's also a renowned speaker and a most sought after faculty for all the institutes, both for the students and the members. He is very famous for his humorous punches throughout his sessions. And he also writes a lot of articles on humor. And he's very busy in Facebook also. Very unusual that a person who is very busy academically is also able to spare time for social media also. He has authored his first book on VAT when it was first introduced in 2005 in Tamil Nadu. And after that, he also created a book on Senvat. His latest book, which is on taxation on digital economy, has just been released, and it's also available on e-version. He wanted me to specifically inform all the participants here that is available on the e-version, can be downloaded, because particularly in the present scenario, we are not able to have this subject with you. You can take it by way of an e-version. As an organization man, he is part of many organizations. Presently, he is the chairman of GST Expert Committee in Hindustan Chamber of Commerce and also a vice president in Revenue Bar Association. And his introduction, his content goes on and on. Let us not spend more time on this introduction. We will definitely go for hearing Vaitheswaran. Welcome, Vaitheswaran. The floor is all yours. And we'll have a program for around 1 hour and probably 90 minutes. After that, we can have a Q&A session also. I request the participants to put the questions on chat. There are 2 people who are technically available to take down those notes and put this question answer in a formal manner subsequently. It will be having a specific methodology. It has been given the independence to Mr. Amit Nahar and Mr. Bharat to coordinate for the question answers. They will be doing it. You will be definitely having that opportunity for participating in these question answers. Over to Vaiti.
Good evening. Thank you, Mr. Sundarajan. And first of all, it's my pleasure to be part of this arrangement to share some of my thoughts. And wonderful to see 4 very famous organizations joined together, the CASC, the Association of Chartered Accountants, the Society of Auditors, as well as the IFA, coming together to discuss some of the aspects involving COVID-19. As Sundar rightly said, so some of us seem to be more busier than ever. And given the fact that technology is able to connect and travel is no longer an issue, every day there is some kind of request that we should address our seminar in Nasik, we should address our seminar in Bhopal, and things like that. And you're not even able to say, no, I'm not able to travel, flight connections are not available. So it's now, if it's not Monday, okay, Monday evening not there, Tuesday morning. So everybody has got their very clear that the professional is available. And to some extent, it is also nice. It makes you read more, it makes you prepare content so that people also enrich. And I'm sure everybody is in their own academic pursuits at this point of time. These are unprecedented times. We have never seen this kind of times ever in our life and career, as Sundar rightly put it. And many of us are very clear that this can cause significant impact for the country and the economy as a whole. And we are trying to look at ways of seeing how it can be mitigated. And my presentation tries to look at all aspects, whether it is the business aspect, whether it is a legal aspect, whether it is a tax aspect. All aspects are sought to be covered in this presentation, including burning current issues, which are already in the discussion, at least among clients, as to what we do going forward. So I would request the organizers to put up the content, which I had already shared, or should I share again?
So you can share the screen, sir, now.
Okay, I'll share it again. So this is a presentation which covers some of the legal aspects. Let me go straight into the presentation. For many of us, pandemic was a new word. We have heard epidemic and we learned what is pandemic. Lockdown was equally a new terminology. And we were wondering, what do you mean by lockdown? In fact, for the first time, on a humorous note, when I was in my teens, I had a cousin who had come from a district in Salem. And at that point of time, she was very interested in seeing the Marina Beach. And being what I am, and I tried to pull a fast one by saying that Marina Beach will close at 5 p.m. But never in my life would I imagine that Marina Beach will actually be closed. Nobody would have visualized that things would be actually closed. So we are now seeing things which are lockdown, shutdown, restrictions, partial restrictions, coding of zones. These are completely different times. There is clearly a disruption at various levels. Business and profession equally affected. Employment is affected. And in the background, you have so many legislations, so many regulations which talk about compliance, due dates are there, compliance requirements are there, payment requirements are there, tax payments are required. People have to go to courts, people have to enforce their rights, people have to dispute some matters. There are contracts which are involved. In terms of these contracts, what are your rights? Every aspect of it is very critical for us to understand. So in this lockdown, what did we see? We first saw some kind of a mandated closure of shops and offices. It was initially a few big shops to prevent the crowds. Then the malls got closed. Then some other shops also slowly started.
1 minute.
Yeah.
There is a request for increasing in the audio. Probably if you can increase the audio from this.
Sure. So the shops and offices were closed, then malls got closed. And then when factories got closed, it became a bit more serious. When production started coming to a grinding halt, plant and machinery got coming in, all those aspects got completely affected. And closure of all these things had its own impact. People are worried as to what's going on. So today, theaters are all closed. There are news items as to what is theaters going to do post-COVID, whether they will be allowed to open. If they are allowed to open, will people be interested to go? Even if malls open at a point in time, will there be kind of enthusiasm to rush to the malls? Restaurants were affected big time. All of them had to close one by one, except for the parcels that we have today. The bigger hotels are also closed. You have travel, tourism, media, entertainment, real estate. At every segment, you have some kind of issues. And if you look at profession, accounting, there are accounting professionals, audit professionals supposed to carry out an audit, a physical audit, an inventory verification, matters have to be checked, matters have to be verified. See, while we all talk about work from home, it is not easy for certain aspects to be done from home. There are something which you can do, some which you cannot do. Some secretarial services cannot be done. Access is not available. You have legal services hit big time because all courts are closed, all tribunals are closed, NCLT is closed, RERA is all closed. So if you look at a pure litigation-based based services, they're completely at home. If you're looking at pure advisory services, why would somebody seek advice at this point of time when their business itself is under peril? Of course, they'll seek advice in terms of whether my contract gives me some leeway or not, but they would not be seeking advice that I'm looking at buying this entity, I'm looking at this particular transaction. It'll take some time for all that to happen. IT services are right now functional, but again, very, very difficult as to going forward because most of the IT services are provided to European clients and US clients. And when US and Europe start cutting down their IT expenses, we'll know what kind of impact it will have. Similarly, impact on support services as well as enabled services. Employees is an interesting perspective. India does not have a fire at will policy. Every employment is regulated. There is some kind of law which provides for it. We had a Ministry of Labor and Employment Advisory dated 20th March 2020 to Employer Association saying that all the employees of public and private establishments are advised to extend their coordination by not terminating their employees, particularly casual or contractual workers, from job or reduce their wages. There were also directions given under the Disaster Management Act to say that you must pay the wages in full and you cannot terminate employees. Of course, there is a big legal debate as to how valid those regulations are, because in the context of disaster management, can you talk about private employment? Can you say that you have to pay? How will the employer pay when he does not have sales, when he's not going to his factory, when his business is not going on? So these kinds of peculiar issues do exist in business, and people are struggling as to what to do for April. And interesting, there are two kinds of disputes which are now pending in Supreme Court. One is a case which is filed by the Journalist Association of various newspapers, including the Indian newspaper as well as the digital media, where they brought out instances of people being fired, divisions being closed, and the salary being cut, and therefore they filed a petition before the PIL before the Supreme Court by referring to the orders passed by the Ministry of Labor and Employment and saying that this goes against it. So we'll know what Supreme Court says in terms of these petitions. There are also petitions in the High Court to the effect that this entire period should be declared as a festive holiday period, in which case wages would be payable. So those are all peculiar issues which are pending in courts. But you also have existing special laws for labor called as Industrial Disputes Act, which clearly deal with layoff, which clearly deal with retrenchment. Layoff is clearly mandated through specific provisions. What are the situations in a layoff? What should be done? 50% of wages is what the law talks about. So how can you have full wages? So these kind of questions will clearly rock the way forward. UK has got an interesting system. They have something called as furloughed workers. whereby UK will simply say that an employee who agrees to be furloughed can stay at home and he'll be paid 80% of the salary by the employer, and the employer will pay 80% salary, and to pay the 80% salary, government will give that money to the employer. So government steps in and pays that money to the employer to pay to the employee, so the employee stays home and he is what is called as furloughed. And after this period of furlough, this crisis gets over and normalcy returns, can come back to normal employment. So nobody gets fired, but they get furloughed in that sense. So interesting, each country has got their own format. We'll have to see what India comes up with. Moving on to some of the subjects which are very relevant to professional chartered accountants, taxation and other laws. So we had this ordinance that came in. I would probably say that the ordinance could have been thought out a bit more and they were covered a little more. It came very quickly. You have to give credit to the government for thinking of this very quickly so that there is not panic. The issues which were facing the industry at that point of time and profession at that point of time was definitely addressed by the ordinance, but probably some more scope could be there to expand that. Probably we'll see fresh changes at a later point of time. So what is the objective? The objective is to relax certain laws, mitigate the hardships faced by the outbreak of COVID. And it does, obviously the ordinance is as good as an act because it is passed, it's probably by the president and then has to get before both House of Parliament. But what is very critical in this ordinance? Any time limit, this word is very important, any time limit specified in the listed legislations, which falls between the period 20th March to 29th June, or any date thereafter as notified by the central government, for completion or compliance of certain actions shall stand extended to 30th June 2020 or such other date after 30th June 2020 as may be notified by the central government. So this is very, very important. You get two important points answered here. One, you are getting some kind of an immunity, some kind of a protection in terms of time limits for taking any action. And the government is sending a message that, look, this may go beyond 36/2020. It is not stopping in 36/2020. That is why one critical word is there, or such other date after 36/2020 as may be notified. So the government may not straight away say that this is going to be a long haul, but all of us know in terms of dealing with various other stakeholders that this is going to be a long haul. This lockdown is not going to be simple. Even if things ease up by 20th to some segments, to May 3rd to some segments, it will still not be total. There will be some kind of partial restrictions in various formats, and therefore life will be completely different. Post-COVID 2019, it will be very, very different in terms of life. Even travel is going to be very different as and when it starts. I don't think travel is going to start by June, July. Let us assume it starts in September. Like how September 9/11 changed the way of air travel because of security. COVID will also change air travel in terms of hygiene and safety. So you will find queues starting from outside with the gaps in between. You'll probably have points where you have to stand in the queue before you enter. You will have probably thermo scanners before you enter. You will also, for all you know, you will have to give a self-certificate that you are not affected by this disease as you go forward. We don't know what can all happen. And airplane seats are also going to be different. I'm sure they will take away the middle seat, and it is unlikely that you will have three people sitting together. Indigo travel is going to be very different from what it was before. So everything is going to change. Life will completely change. And for people who have done 20, 30 years of practice, is going to be an interesting way. We have seen everything, I would say. In fact, on the other day, I'm sure all of us are experiencing this. All of us go to the terrace in the evening or any open space in the houses here that we live. And we tend to see cleaner skies. We're able to identify stars and try to look at things. And a few days ago, when I was on the terrace, about 4 of us, 5 of us were there from the entire flat. And all of us were suddenly pointing out to the sky and shouting that there is a plane. So I was just transported back to my childhood that, plane was such a rare thing to see in the sky, and then you would shout that a plane has come. And after so many years, we are now doing the same thing again. So we're definitely going back in time in terms of so many things. But we will come out of all that. So this legislation is listed as all relevant to us: Wealth Tax, Income Tax Act, the Commodity Transaction Tax, as well as the Direct Tax Apkoishwas. What is this extension? It will be applicable to completion or compliance of acts such as proceedings, passing of orders, issue of notice, communication of date of hearing or something, notification, sanction, approval, filing of appeal, reply, application, furnishing of report, return, document, statement, etc. So everything is covered. So if you're required to do something by this due date and this due date falls in this particular period, you are given this immunity by this legislation. Even after that, you can do it, and it will not be treated as a violation, nor would you be required to file a continuation of delay petition, because this act has virtually extended the due dates for all these things. Now, this is very important from people who had sold immovable property and were planning to make certain investments. They had some time. They could have put in bonds by a particular cutoff date, or they would have committed to construct an apartment, to construct a house, or purchase a house. They were given gone under the capital gains account scheme, and they would have had certain deadlines and time dates by which they should have done it. Now, all that gets extended because your time limit now stands extended 36/2020, or such other date after 36/2020, as may be specified by the central government. Similarly, SCZ, there are relaxations to say that beginning of manufacture or production of articles or things or providing any services referred to in 10AA, where the LOA is required to be issued, has been issued on or before 31/3, we have some extension as contemplated by the Act. This is the most important aspect. Where is the money to pay the tax? Nobody has got funds in terms of cash flow, because all of us are aware that cash flow is very critical. How much ever you have reserves, you need to manage your cash flow quite well, and tax is a critical payment that has to be made. You have advance tax, you have TDS, you have all those things. It is unfortunate that this Act, instead of waiving interest, has only said that we will say that this amount should be paid on or before 36/2020, and in case after that, if you're going to pay, your interest is going to be 9%. Now, I don't think that 9% is the relief. What they should have done is they should have said no interest at all. There is no, I'm sure government did not make money out of interest in terms of these delayed payments. The fact that he's making a payment itself is a big thing, and therefore, if he somehow managed to make this payment after this period, no point in charging interest at 9%. And then the one that is in the news, the PM's Care Fund, Section 1023C, and is amended to include the PM Cares Fund. You also have amendments to Section 80G, subsection 2, to cover this PM Cares Fund. And PM is, of course, probably the first trust that would have fallen under the new category of being eligible for benefits as soon as it's applied for. And we have issue. PM Care is also qualifying for CSR after the amendment to the Companies Act schedule. The Direct Tax Vivad Se Vishwas Act, which had this cutoff date by 31st March, where everybody was required to make a payment by 31/3, now it stands to 36/2020. I don't think this is going to work. 36/2020 is also not enough for people to find out cash to pay, because now when you're looking at cash, even the earlier days when the scheme was analyzed, the payment for tax was an issue. You know how to generate money for paying tax. Now, if you manage to identify some source for cash, you'll probably pay statutory liabilities. You'll probably pay all your employee salaries and wages. You will not look at the Vivad Se Vishwas Act. You'll probably say, I will dispute the amount for some more time. All the time limits specified in the Central Excise Act, Customs Act, all the Customs Tariff Act, Finance Act, which relate to the service tax, whatever time limits contemplated. Of course, it's interesting that they stood prior to omission of Section 173, falling in the period from 23/2020 to 9/6/2020. Now, this is an interesting question. Can you amend an act which technically has been repealed? If you look at Central Excise Act, it has been repealed. If you're looking at Customs Tariff Act, it has been modified. If you're looking at Finance Act, Chapter 5, it has been omitted. So Section 173 has done all those things. So can you go and re-legislate those things to give a fresh time limit for a show cause notice or something? Of course, this might be beneficial in the context of an appeal which is pending for the past period, but this is an interesting question which can probably come up, given the fact you have this recent Gujarat High Court judgment in the context of the VAT as well as Article 246A. Then there are minor changes in Sabko Vishwas, which is not very relevant. I'll skip that. A very interesting section has come to CGST 168 capital A. Now, this provision empowers the government to extend the time limit by notification. And for the first time, they have defined force majeure in this legislation. So the government can take a call as to what would constitute a force majeure. Force majeure means a case of war or epidemic. So they've identified this as an epidemic and notified the power to empowered through the legislation to ensure that notifications have been given. And based on this notification, based on this power under Section 168, a number of returns have been given in GST. Most of you have already seen enough of those notifications in GST. Supposed to say that, let us say you're required to file, you're in a category where your turnover is above 5 crores and you're required to file your returns for February, March, and April. The due dates remain as it is. So let us say for your March return, you're supposed to file by April 20th. what they've said is you can take some time. You're allowed a 15-day grace period. So if you file before May 5th, nothing happens. That means obviously you have to file and pay the tax. But if you file after May 5th, you'll have to pay 9% interest. You're allowed this 9% interest up to 24th June 2020. After that, you're required to pay interest at 18% and all other penal action can follow. So here again, just like income tax, my point is, why make 9% interest on this? They could have very well waived the entire interest by allowing an extension of due date. So this is very peculiar because they've not extended the due date for filing the returns, but given a peculiar provision in the form of a grace period and a waiver. Now we go on to other aspects. Let me share some of interesting things that have happened in this lockdown. I've come across cases where some of the tax authorities are sending assessment orders via personal email ID during lockdown period. I have instances where I've seen an assessment order where the date is 7th April or something, and it has been sent by email, and it is just a word attachment, no signature. And it also says that if you don't pay the amount within 7 days, bank attachment will follow. This is completely not on. On one side, you can't close offices, you cannot close businesses, you cannot ensure that everybody stays home, and you cannot have the tax departments parallelly working and sending these kind of demands. So this is completely not anywhere within the ambit of fairness or equity. And while government is definitely an essential service, it doesn't mean that they can issue assessment orders through email at this point of time. While we are getting into e-assessments and e-appeals and e-courts, this definitely is not the time to pass ex parte orders through email. And of course, the interesting part of the order was personal hearing was fixed and you didn't come. How can anybody come for personal hearing during lockdown? This is one. Second is there are instances of email coming in from authorities which says whether you're willing to conduct the hearing through a WhatsApp video call. And that email says that if you're agreeable, we'll fix a date. And on that date, you can go to your office or to your consultant's office and conduct the hearing through WhatsApp call. Again, this is crazy. How can you go out from your house to your office for the purpose of conducting a hearing, especially during lockdown period? All these things probably can be contemplated after lockdown, after things settle down, and we need to understand how these things work instead of blindly going and adopting this technology. And again, while we are definitely, this meeting is on a Zoom platform or we are looking at a YouTube kind of a scenario. We don't know whether adjudication matters and litigation matters can be conducted through these kind of forum, because you have the secrecy issue which can always come back. You have clients' data that may have to be shared. So this kind of questions can really come up, and unless we have our own robust, sophisticated, secured infrastructure provided by the government to enable these kind of video call related assessments, it might be risky from a privacy perspective. Interestingly, Supreme Court has already given enough relief by passing an order under Article 141 and Article 142, where they very clearly said that any appeal, reply, etc., if you're required to do certain things by a certain due date, don't worry. All that will stand extended with effect from 15th March 2020 till further orders are passed by the court. So this is much more wider than the ordinance that was issued. And therefore, even if the ordinance time period collapses by the 30th June 2020, till Supreme Court passes further orders, you will still have some kind of time in terms of appeals, replies, etc. Now let me go into specifics. Work from home. People are working from home. People are able to quickly understand what is required. In fact, a lot of companies have already enabled work from home environment even before. But now people have given, there are some, in fact, I find certain clients would anticipate this lockdown. 1 week before, 10 days before, certain clients had done a massive purchase of laptops and given to employees and provided network and even reimbursed the cost for operating their Wi-Fi environment to ensure that they're able to work. So they were able to predict that 2 weeks before the lockdown itself that something like this is going to happen and they may have to have a backup. There are e-commerce companies who have 6 or 7 people who are completely working backend, and with all the facility, they're able to operate their facility which they're operating. So a lot of companies have actually thought through it. Some companies are using their own employees, where the employees are using their own gadgets at home, and in that process, there are decisions being taken from home. So the question that arises is, assuming contracts get concluded by employee action from the home, or other core activities taking place at the residence, now does it become a permanent establishment for the purpose of income tax? Now, Supreme Court in the case of Formula One World championship when they identified that that particular facility made available was at the disposal of the foreign company. They talked about certain key factors, and that key factor may be really missing as far as work from home is concerned. Interestingly, commentary to Article 5 of OECD very clearly says that even though part of the business of an enterprise may be carried on at a location, such as an individual's home office, that should not lead to the conclusion that the location is at the disposal of that enterprise simply because the location is used by an individual, for example, an employee who works for the enterprise. The integral aspect is continuity and performance, and then only PE is created. Now, this probably gives adequate clarity as to whether an individual can trigger off a PE. And OECD went one step further and gave a particular analysis through its secretariat for COVID itself. So they said that post-COVID, if somebody is doing teleworking or work from home, that by itself will not constitute a permanent establishment due to prima facie lack of permanency or continuity, and given the fact that the enterprise would have no access or control over the establishment, that is a home office of that individual employee, except through that one employee. So these make it quite clear that mere working from home may not trigger a PE. But there could be other problems. There could be scenarios where certain foreign engineers are stationed in India, and they come to India for a particular project, and they are very clear that they have to go back by a particular time to avoid triggering of the PE in terms of the construction, in terms of the establishment, in terms of number of days spent here, or in terms of residential status, etc. And unfortunately, now they cannot travel. All of them are stuck somewhere. Wherever they are, they just remain where they are. So the days or the thresholds would have been breached. So what happens those kind of stages? Are we then now triggering place of effective management? So what has happened is that travel restrictions and strict quarantine measures have caused relocation of employees of all verticals, including senior managerial employees such as CEOs, etc. And this raises a concern regarding place of management of enterprise as POEM and also residential status. And again, OECD in its answer very clearly says that this should not trigger it, because if you apply the tiebreaker test, you may end up having residential status. But the challenge is much beyond this. OECD might give its clarification and say that this would not trigger a status. But COVID will get over, COVID relief will happen, and people will forget everything, and soon a vaccine will be discovered. And once a vaccine is discovered, everybody will just get a shot. And once they get a shot, they feel immune from COVID and they travel along, and the year will get over, the next year will happen, and then assessments after will happen. And when assessments are taken up, none of these would be relevant. Nobody is going to refer to what went through lockdown. People have forgotten lockdown. Like what happened to Chennai floods. I'm sure many of us have completely forgotten Chennai floods, or for matter Varda. It's all gone out of our mind, except when you discover that some files are missing because of the flood which have hit your office at that point of time. So like that, you will soon discover that this is a thing of the past. And that time, the tax department is not going to give you a sympathetic hearing. They're going to look at the statutory provision, read the residential provisions, read the number of days, look at the DTA, and then say you're also a resident of both countries at this point of time. So my point is the government should act now and issue appropriate circulars now itself when the matter is hot, and say that these things should not trigger and would not trigger. And it is also important that we set the tone first, because Indian companies which have companies outside India, which control companies outside India through equity, may not be in a position to hold board meetings outside India, may not be in a position to travel to places outside India, and all the decisions could be taken somewhere in India. And that should not trigger an effective management for those companies, and those kind of pressures should be completely avoided. So we need to look at some kind of government intervention on this point. Now, this is something which is totally relevant to the entrepreneur as well as the employer. Employer has got client contracts. Now, based on the client contracts or client engagement, he is providing services. Now, his services could be consultancy. His services could be technical support. His services could be IT product development. His services could be some critical data management of a company. And this employee is now suddenly in lockout. He is at home and work has to go on. Therefore, one email is sent from the employer saying, can you do this? I'm sending you the files. The files are downloaded. The employee starts working. Productivity increases. Work happens. But nobody examines what is the contract which I have with the employee. Do I have adequate confidentiality obligations in those contracts? Is the employee adequately bound by data privacy? These are client data. So when the employee is working on the client data, is there not a risk of data privacy? Secondly, if I'm providing these services to a client and when I'm getting the work done through employees working at home in a different kind of IT environment, using their own gadgets, using their own Wi-Fi, using probably public email accounts, is there a big risk? And if so, should I not inform the client or get permission from the client? So it is better that upfront you talk to the client and say, if your work is so important, we can still do it, but we have to do some relaxations in terms of how we do it. And one of the ways we do it is that we get our employees to work at home. So we can only promise certain things, but we cannot go beyond that. But many clients have got many companies have got clearance from the clients and people are working from home. And you should also instruct employees as to how to work at home, what kind of protection they can take. Of course, there is, as my friend Whittle always say, even though you're secure to the extent you think you're secure, you're still not secure. So in IT environment, how much of protection you have, there could still be some vulnerabilities. But to the extent you can, some of the basics which are critical should be shared. The security team should have a chat with the employees before they start working on this, because it's very easy that initially you start working and then the data leak starts and you have no control of what's happening. So work from home guidelines will have to be there. And future, what is going to happen? If this is working very effectively, today it is working quite well, it may become the new norm. And suddenly companies might decide that why do I need 1,000 people sitting in a huge center where I have to use 100 buses to bring them from morning and go and choke the entire OMR every day? Why not ask them to work from home itself? Anyway, they're working more than before, because most employees who work from home use it as an advantage to escape from other things at home. So if there is other work from home, the first thing they say, no, my boss is on a call, I have to go and do something, and therefore they escape whatever home chores they're supposed to participate. So many people are doing, actually their productivity has increased, and there is much more pressure because there is no break, there is no chat possibilities. Of course, WhatsApp is definitely a distraction, but despite that, people are working more from home. And I'm sure professionals also, I'm sure no professional has gone to so many seminars ever in their life. And even when the CP credits were there, the institute offering CP credits, only at the last moment people for accumulation of credits went through. But genuinely, people who are interested, you can go for one Monday seminar, you can listen for 2 hours, and you do it continuously Tuesday, Wednesday, Thursday, Friday. But people are doing it. I'm amazed by the number of audience in every seminar which come and they listen to it fully, and the questions come. So everybody is actually working beyond their potential, which is good in a way. At the same time, we should understand that this can become the new norm. So when it becomes a new norm, then what happens to all the OECD guidelines? What happens to all the residence concepts? What happens to security related issues? The huge impact will be on real estate. If 1,000 people are going to work from home, then why would I need such a big swanky office? So I would get rid of real estate space. So commercial real estate for various businesses can change. Why do you need multiple branches for even an audit firm when you're able to work from home? Anyway, that audit employee is not in this office. Even if you create a branch, he's always at site or client location. From one client location, he jumps to another client location. He's already working from home with his laptop. So since he's already on the move, it may be even more practical to think at cost cutting in terms of things. And going forward with what economy is, people will look at these kind of solutions. So my guess is that new technology will evolve for work from home, and it become more and more secure and more live. The key thing is how to match what the person speaks and how get his expression. So that would probably be the future as technology improves. Now, having touched about tax, having touched about employees, now I'll go on to contract related issues as far as COVID is concerned. First, let me explain this concept called as doctrine of impossibility. In fact, we are discussing these doctrines after studying them in probably third year of law. I'm talking about 88, 89 kind of thing. Most of the lawyers would have read this in their contract law. Chartered accountants would have read them when they're in the Indian contract at subject during examinations. And the principle would have also been tested to some extent in tax matters. So lex non cogit ad impossibilia simply means you cannot compel a man to do what he cannot possibly perform. Law cannot compel a man to do which he cannot possibly perform. The classic example which I gave you is an assessing officer issues a hearing notice, and that hearing notice comes by email, and the hearing notice says, please come for hearing on a date which falls in the lockdown period. Now, I cannot go on. I cannot violate the lockdown period and go for hearing just because hearing has been fixed. You cannot compel a man to do what he cannot possibly perform. You cannot say, no, he can break the lockdown. He can say, I'm going for vegetables and come for a hearing. No, that is again breach of law. You cannot breach a law to comply with another law. So this concept is very important. So this came from Roman principles, where a thing that is destroyed without the data's act or default cease to be attainable. Now let's look at some English case laws as to how this has been evolved. Original thinking was very bad. Original thinking was, you cannot take any window of eventuality or impossibility. You have to comply with the contract, and you should have visualized every possibility. So even if the worst of things is supposed to come and it actually comes, you should have imagined this and put it in your contract. If you have not put in your contracts, then you cannot claim relief. This was the way the earlier thinking in 1647 and 1809, where in 1649 in Paradigm versus Jane, the lessee was made liable to pay the arrears of rent even he was evicted as an alien enemy. So that was the kind of decision that was given in the initial days. Then came the law that slowly evolved, saying, can there be an implied condition? So the implied condition was such that there was an opera house, and this opera house was being let out for holding concerts. And one point of time, the opera house itself had a big fire accident and was completely destroyed. So the point was, the whole purpose of booking this hall was to hold a concert. If the concert itself does not exist, then the implied term collapses. So my performance depends on the continued existence of a given person or thing. And therefore, that condition is implied. That impossibility automatically arises when that thing is completely gone, and that thing will excuse, that absence of the thing would excuse my performance. This was the view in Taylor versus Caldwell. This was, of course, criticized and overturned in another case called as Penalpina. It's not able, I don't know whether you're able to see it in the full screen, but in the Penalpina case in London, there is the street called Kingston Street. And in Kingston, in those days in London, after a point of time, certain buildings were identified as protected structures, work of art and architecture, and therefore government passed an act and said that you cannot deal with these buildings, you cannot break these buildings, you cannot modify these buildings, you cannot construct anything in this building. So there were such buildings identified. One such building was also in the risk of falling down, and therefore the government decided to protect that building to ensure that that beautiful history is not lost. So to carry out all the repairs, etc., the entire Kingston Street was blocked. So this is somewhat similar to one or two streets of Mambalam getting barricaded, or some streets in Saidapet getting closed because of contamination. So the entire street was completely blocked, and the block continued for a significant period of time. And during the period when that entire street was blocked, there was another warehouse which could not do any business because nobody could come to Kingston Street. So the warehouse lessee refused to pay the rent, saying that I won't pay the rent because my entire street has been completely blocked, and I'm not able to do any kind of work. Now, the court ultimately questioned the Taylor versus Caldwell and said that this is a very small period. They talked about a 20 months period in a 5-year lease period. This 20 months period of blockade is not enough for you to get out of frustration. You will still be liable to pay the rent, was the decision in the House of Lords. This maxim lex legit non impassibilis has been applied in our Bombay High Court matters in Indian courts, where in the context of income tax itself. So many of you know that 54 EC contemplates that you have to put your capital gains in certain bonds. And at that point of time, there were certain notified bonds, and assessee wanted to invest in those bonds, but those bonds were not available. And since bonds were not available, assessee could not invest in the bonds by the time limit. And then the court said that this very clearly indicates that he can claim the investment by putting in a particular bond, but if the bond is not available, where is the question of you denying the benefit of exemption? And they applied this lex non cogit principle. This lex non cogit principle is also applied in the context of VAT, where in the case of a Delhi High Court, the law said that a buyer availing input tax credit must demonstrate that the seller has paid the tax. And if the seller has not paid the tax, then action can be taken against the buyer. Now, the court applied this doctrine and said, how can you expect the buyer to go behind a seller and find out whether he has paid tax or not? So this is something which is an onerous condition, and therefore said that you can't expect the buyer to do the impossible. So they applied this lex non cogit principle. I'm sure this lex non cogit principle will also be tested in GST, because GST also has got a similar provision, section 16(4), where one of the conditions is that the supplier must have paid the tax. So how can the buyer find out that the supplier has paid the tax? So the Arise India judgment in Delhi High Court would be relevant even in the context of section 16, not 16(4), 16(2), in the context of conditions. Then the law of contract further evolved. We had this Davis contractors principle, where they said that if frustration occurs, the law recognized that without default of either party, an obligation has become incapable of being performed. Parties are agreed to perform, but something happens. And the way something has happened is that they're no longer in a position to perform their obligations. Now, let us look at this kind of scenario in post-COVID. Somebody wants to acquire, or somebody is looking at a tourism business or a travel business or something related to airlines. Nobody would have expected this kind of collapse to happen in this kind of segments. Now, can they get out of this on the ground of frustration? Now, those are the things which we'll have to interpret going forward. Then comes this famous case called as Krell versus Henry. Now, this gave a very interesting perspective. What happened here was there was this property which had a beautiful view of the, if the royal procession takes place, this man said that from my balcony, from my apartment, you can see the king's royal procession when he's coronated. We have read this case law years back in contract law. I still recall Professor Anantraman talking about this case law in my earlier accounting class days. So this is a very interesting case law where what happens is that the king did not get coronated. So Edward VII did not get coronated. Therefore, the coronation did not take place. Since the coronation did not take place, the tenant said that the whole purpose of taking your apartment was to watch this. And since I can no longer watch this because the coronation is no longer there, I will not pay the rent. The court agreed with this principle by applying what is known as the doctrine of frustration, because the cancellation of the king's procession has frustrated the contract completely. Now, this doctrine of frustration, as we call it in English law, is manifest in section 56 of the Indian Contract Act. If you look at the second bullet, a contract to do an act which after the contract is made becomes impossible. So I've executed a contract, I've agreed to do something, whatever I've agreed to do becomes impossible. And why does it become impossible? It has become impossible because of some event, and that event I could not prevent. Therefore, the contract becomes void. Now, this is a very important condition, section 56 of the Contract Act. When section 56 will apply, when it will not apply, I'll discuss a bit later. Courts have applied 56, and we have the Supreme Court judgment in the case of IFCI, where they've said there are three basic conditions that have to be met to satisfy section 56. One, you must have a contract which is subsisting. Some part of the contract is still to be performed, and the performance has become impossible after the contract is entered into. Now, this performance has become impossible is a critical test which anybody will have to satisfy if they want to say COVID is the reason for getting out of a contractual obligation. And that is not going to be easy because it is totally factual and based on what you have signed in the contract. And what is impossible? You have some decisions. You have the Satyavrata Ghose of the Supreme Court, where they said word impossible has not been used in the sense of physical or literal impossibility. The performance of an act may not be literally impossible, but it may be impractical and useless from the point of view of the object and purpose which the parties had in mind. Now, you may have to visualize scenarios and then say, if I continue to do this, it would be virtually impracticable and useless in the given scenario in terms of post-COVID. If for post-COVID, certain businesses become irrelevant, certain products become irrelevant, certain consumption patterns become completely irrelevant, and there are long-term contracts signed for providing those kind of products and services, one may have to examine this particular decision and the principle and see whether we can apply that. If an untoward event or change of circumstances totally upsets the very foundation upon which the parties rested their bargain, it can very well be said that the promisor finds it impossible to do that which he promised to do. This can also happen in terms of you have decided to acquire a particular company, you're in the stage of LOI or in the stage of MOU, where certain basic parameters have been identified that these are the reasons why the company is investing in this particular business, and those reasons no longer exist, the reasons collapse, then the investor may look at as an exit window and come out of it by using these kind of provisions. But let me tell you, what is impossible is not easy to satisfy. In this decision, the case of Sakiroglu versus Nobly Thrall, we have this situation where the Suez Canal was closed. And Suez Canal was the route for which goods were usually, it was the easiest route for it to go, and effective and economical route. There was a contract for sale of groundnuts, and the company said that we are not able to move because Suez Canal is closed. But the court said that you can go through some other route. If Suez Canal is closed, so what? You take a longer route and deliver the goods. And therefore, you cannot say it has become impossible. It may be slightly impractical, but you can still perform. So if you're able to perform an obligation with a higher cost, if you are able to perform your contractual obligation with higher incidence of cost, that may not be a window for you to say it has become impossible. Your increase in cost may not be an answer going forward, is the message and lesson that we get from this case law as far as Suez Canal is concerned. Now we come to this popular term called force majeure. By now, everybody is talking about force majeure. Every newspaper is carrying articles about force majeure. So what is this force majeure? It's a French term which came into the statute books. And it is basically a contractual term. Please understand, force majeure is clearly what you have put in the contract. If you have put in the contract a force majeure clause, then the entire contract is governed and discussed through force majeure. You may not be able to go to impossibility principles. You will have to live with force majeure clauses. Now, way back in 1915, in the case of Matsouki versus Priestman, there was a contract for delivery of a steamer, and there was a clear force majeure clause. And the force majeure clause said that suppose there is a strike, or suppose there is a strike which prevents the working of the castings or the machinery, or suppose there is a strike at your subcontractor. All these are good enough reasons for excusing the delay in delivery of performance. So apparently there was a coal strike, and there was a machinery breakdown at the factory level that was also covered. Then there was another strike at the subcontractor level, and some workers went for a football match, and workers also attended the manager's funeral. So all these were given as a cumulative set of reasons for the delay in performance. The court accepted that coal strike, machinery breakdown, as well as subcontractor related strike are all force majeure accepted. But they said somebody going to a football match, if you cannot control, that is your problem. Somebody attending a funeral and leaving the factory, that is your problem. So you cannot say that force majeure will apply to those kind of clauses. Similarly, there is one decision where they said that you must have clear clauses. You cannot simply have a general, force majeure clauses which are not specific. If you have general clauses, the courts are unlikely to give a very wide kind of interpretation. The another terminology that is everywhere used is act of God. In fact, it will be interesting to see how some of the rationalists in Tamil Nadu interpret act of God in their contracts. If they have such a clause, whether they're going to rely on that clause, or they'll say that no, we are completely rationalists, we don't believe in this clause. So act of God is a terminology which is also found in most of the contracts, and you have act of God also interpreted by the in the earlier judgments of English judges. All causes of inevitable accident, fortuitous, may be divided into two classes. Those which have their origin either in the whole or in part of the agency of man, whether an acts of commission or omission, of non-feasance or of misfeasance, or in any other case, independent of the agency of natural forces. It is obvious that it will be altogether incongruous to apply the term act of God to the latter class of inevitable. So they were more discussing with natural disasters, tempests, storms, floods, etc., and they all brought them under the ambit of act of God. So it is not as if they said that it has got a religious connotation, but something which is beyond your control, something which is beyond the human agency's hand, human's hand, would fall under the ambit of this particular act of God. Now, this is a standard clause of force majeure. In fact, I was curious as to whether my own language had covered this, and apparently I looked at some of my old agreements and I found, which I drafted. This was my contract which I drafted in 2008, and of course I don't know whether you're able to see the full slide, but I've covered epidemic. In 2008, I had contemplated that epidemic could be a force majeure and put it. Of course, I didn't know the word pandemic at that point of time. So we learn every time, and probably future contracts will keep adding those words. So force majeure, this is a very comprehensive clause. Not many contracts will have this kind of clause. Most contracts will have war. Most contracts will have riot. Most contracts will simply say act of God. But if you have a natural disaster or a natural calamity or something beyond your control, that should take care. Then we have this famous judgment called Energy Watchdog of our own Supreme Court, where the Supreme Court said that if an untoward event or change of circumstance totally upsets the very foundation upon which the parties entered the agreement, it can be said that the promisor finds it impossible to do that which has promised to do so. But again, court kept saying that, look at your contract. If you have a force majeure clause, that will prevail over Section 56. So whether Section 56 applies or force majeure applies is all something which we have to look deep into the contract. In fact, now everybody is asking this question, sir. I have a situation where I'm a tenant. I'm not in a position to pay the rent. The office premises is closed for 3 months. What do I do? There is a commercial tenant who says that I'm running an IT office and I'm not able to open for the last 1.5 months. Is there any way I can get out the rent? There are construction contractors who say that I've got construction commitments to deliver. I'm not able to deliver. The developers are saying I've got agreements with my customers. I have to hand over the flat by so-and-so date. I'm not in a position to hand over these flats. Now let's look at each of these segments from what has been done elsewhere. For example, if you're a developer, you're governed by RERA. And if you're governed by RERA, RERA has come to the rescue by giving certain notifications and orders where due dates have been extended. So if you have committed that you're going to deliver a project by so-and-so date, there has passed orders to say that that date stands extended by so-and-so date. And if you are not under VERA and your contract talks about certain committed dates, you have to look at the contract to see whether you are excused in terms of delay, etc. Most developer contracts will have adequate force majeure clauses. So if the force majeure clause are there, you may have to examine that and intimate the customer if required. Now, a customer says, sir, I've agreed to buy this apartment and I have agreed to pay EMI every month. And because of this particular COVID, I'm not able to go to my office and my salaries have come down. I'm not getting salaries. I can't pay the EMI. Now, that may not be possible. Your payment obligation will not fall under force majeure because you may find a way to still make the payment. Your EMI with bank may have been protected, but your EMI with reference to developer may not be protected, and you may have to seek indulgence from the developer. And most developers are likely to be much more fair at this point of time, and nobody is going to insist on strict timelines because everybody is in trouble. Quickly moving on, we have talked about COVID. COVID ancestor is SARS. So SARS was also original, had a big impact, and we had some of these special. Some countries got affected, and airports had for a long time special counters to check whether somebody has SARS or not. Now in SARS, look at this Hong Kong case law: Li Qingwing versus Yuan Jian. A tenant who was subject to a 10-day isolation on account of SARS, who was on a 13 months lease, simply said frustration, and therefore I want to discharge the lease. Now, mind you, frustration would mean that you want to terminate the lease. You may not be able to use COVID to terminate leases, but you may probably use COVID, depending on your force majeure clause, to suspend your payment obligations. That can be very different. You cannot say, I'll walk out of the tenancy because of COVID. But that again depends on how COVID develops, how the aftermath of COVID develops, whether retail segment is completely affected and people go to online. In fact, India will become much more digital than what it was before. If digital economy was my theme for the book, and I had certain ideas in terms of digital economy, which is going to happen. Even I was surprised by the pace at which digital economy is going to happen as far as country, because everything will become digital, because you don't want to go to the shop, you don't want to go meet somebody, you don't want to touch something, and you prefer that your point of contact can be minimized to the person of delivery because that is in your control. So you will soon find that the enthusiasm to go to the shop. Of course, now everybody wants to go to the shop because they are at home. This is a different period. Because of the lockdown, a fellow who normally does not go to a shop wants to go to the shop every day, because he wants to step out of the house and he uses, I'll go and buy vegetables, I'll go and buy groceries. He wants to go 3 times outside because he wants to step outside. But that may not be the scenario later on. He would still have his scars and fears, and therefore he doesn't want to go through his mask experience. He will simply say that I will order online, because I will deal with one person delivering. I will clean up the stuff and take it inside. So e-commerce would come in a much, much bigger way, and the concept of digital economy will be very, very relevant. And look at this kind of decision where the court said that no, your lockdown doesn't mean that you can get out of tenancy. There's some problem with this slide, but I just explained this 2008 financial crisis. When 2008 financial crisis happened, the question that arose was 2 decisions came up in the US. One was SR had planned certain investments, and they were supposed to put certain construction projects, certain projects in the US. And they said that because of the 2008 financial crisis, my ability for funding the project is completely collapsed. The steel prices have completely collapsed, and therefore I'm not able to raise funds, and therefore force majeure will apply. So when 2008 financial crisis was given as an excuse for force majeure, the court rejected it in the case of SR Miniosta, where they said that no, this can't be an excuse. Your overall catch-all phrase in force majeure may not be sufficient to cover this, and we cannot accept 2008 as a crisis. You must have anticipated financial crisis, must have anticipated funds, inability to raise funds, and therefore this won't be an excuse. But in the same 2000 financial crisis was quoted in New York in another decision. In that decision in New York, the assessee's clause said that force majeure included change in economic conditions. So the terminology change in economic conditions was accepted by saying that yes, economic conditions have changed because of the 2008 financial crisis. We'll accept your force majeure clause, and therefore the company which had contractual obligations to make some payments was able to get out of the payments. So why I'm giving these examples is that this COVID might be one set of COVID would be identified definitely as something which falls within force majeure. But because of that, what are the consequences? That can be very, very important. That can be debated. So one is an example of what we discussed in terms of SARS. The other one is what is called as 2008 financial crisis. And the last one, which I'm going to discuss, is the Brexit, which is 2019 decision. I think this is the last but one slide. So 2019 decision is the Canary Wharf versus European Medical Agency. So what happened here was European Medical Agency had its headquarters in London. And then once it was decided that UK would leave the European Union and take steps to withdraw from the EU, they had certain agreements called withdrawal agreement, etc. But one of the key points was EMA decided to shift its headquarters from London to Amsterdam. And therefore they said, since we are shifting from London to Amsterdam, and this is a frustration event that has occurred, I will not pay rent. I'm not obliged with reference to lease conditions. The court did not agree. The court said that the lease will not be frustrated on account of UK withdrawing from EU. It is neither a supervening impossibility nor frustration. You're obliged to continue to perform your obligations as far as the lease is concerned. So what I'm trying to, the summary of all these principles, let me take a couple of minutes to explain. Now, you may as a professional might have entered into certain contracts, or your clients might have entered into certain contracts. There could be agreements to perform certain services. There could be agreements where you're committed to achieve certain things. There could be contracts where you're required to pay on a monthly basis. There are contracts where you're required to pay rentals. Now, you cannot apply a standard principle to any of this and say, this is force majeure, this is not force majeure, this is impossibility, this is frustration. Each contract will have to be examined in terms of the overall objective of the contract, the relevant clause, and all of the surrounding clauses which has got an impact on it. And biggest challenge would be where you don't have a contract. There could be parties who would have been working on this relation for months together based on a purchase order. So let us say purchase order has been placed saying that you are supposed to design, do engineering, fabricate, and make this huge equipment. And that equipment is probably used by the buyer for a particular product, which may no longer be relevant post-COVID in the market space. So if that product is no longer going to be relevant in the market, the company which is manufacturing this may not be interested in buying the equipment, but they placed the purchase order. Now, how much of it can be cancelled? Is purchase order a contract by itself? Those kind of questions will come into the picture. Or is it frustration or difficulties? So impractical versus impossible. Each question will have to be examined. So if you take a rental perspective, take a retail outlet. A retail outlet is sitting in a mall, and the orders have been passed by the government saying that all malls have to close. So when all malls have to close, obviously you cannot break the law. You cannot sit in that mall. You cannot run your outlet, and you cannot have walk-ins. If you don't have walk-ins, you don't have sales. If you don't have sales, you don't have revenue. If you don't have revenue, you can't pay rent. So one is you're not able to carry on the business at all. So can you say that there is a doctrine of impossibility? It can be very difficult, but can you request the landlord to suspend the rental obligations for this period or take a discount or some kind of relief? Yes, that may be possible. So going forward, it is better to discuss and negotiate rather than take a very, very powerful litigious position, because neither party is going to succeed in terms of litigation. It's going to drag on for some time, but it will still go to litigation where both parties are unable to break the ice. And there could be arbitration clauses or there may not be arbitration clauses. And similarly, there could be whether the orders which force the mall to close or outlets to close can be additional grounds to say that my contract gets suspended during this period of locking. That again can be a new matter of debate which has not come up before. So you will have interesting principles that get evolved over a period of time. So as I said, you may have to check the contract and see if there are clauses and then the scope of the clauses. If there are no contracts, look at the surrounding circumstances, look at Section 56 of the Contract Act and see if you can get some kind of relief through Section 56. If you're not able to apply Section 56 directly, you have to look at the doctrines. You have to look at either doctrine of impossibility or doctrine of frustration and see whether that can be extended. You also have to look at every single government order that gets passed in this. Keep a track of every single state order or central order that gets passed, and then see how much of it can be relevant in terms of your contractual obligations. So these are some of my thoughts as far as legal aspects concerned. Now, my last slide would be going forward. What is going to happen? Every legal concept that we have read in the past, we will revisit. If we talk about Krell versus Henry, if you have talk about Taylor versus Caldwell, if you talk about our own Supreme Court decisions, you will soon find that throughout the world, new decisions are likely to come. Because this COVID-19 has not affected few countries, it has affected almost every country in the world. So every country has got its own Supreme Court, and in US, every state has got its Supreme Court. So you will have every decision which looks at it differently. The UK principle may not be accepted in US, the US principle may not be accepted in South Africa. Indian Supreme Court can have a completely different view. So it is going to be a new set of case laws that are going to come post-COVID. And COVID would have even huge impacts in terms of international transactions. For example, one country may open its lockdown, another country may not open its lockdown. So for example, today, there are companies in India which are manufacturers, which has got firm export orders, but they're not able to export that much because of the closure. They're not able to manufacture. Only when the factory is able to open, they can manufacture. There is a slim permission. They can do a little bit of export, and a little bit of exports are happening, but that's not enough. They have firm orders from countries where those plants are functional. So the buyers are now likely to say, look, are you going to supply, or do I look at another source of supply? So that becomes a critical problem. So there is pressure saying government should open, economy should get immediately open. Now, if economy opens quickly, then you may have the same problem in another way when multiple people come into your factory. So every company is facing a severe battle in terms of whether they may lose a market. At the same time, there is an opportunity because some other country has got this kind of a problem, and we may get an opportunity for an order. So I would say it's a mixed bag. You have to look at opportunities. There will be huge opportunities coming in. And for professionals, I see unbelievable opportunities. I'm not a person who's a pessimist. I feel that this lockdown period is a very temporary phase as far as profession is concerned, because profession many of the chartered accountants will say that, sir, I'm not able to file my GST returns. My clients are not interested in filing GST returns. My clients are not filing tax returns. They're not paying their taxes. My revenue comes only from all these things. Therefore, my revenue is completely dried down. Yes, I agree. You will have that impact. Why, for that matter, even legal services will be down. Why would tax lawyers get paid when tax appeals don't happen? So obviously, every profession will go through this. But one difference is that if you're able to utilize this time wisely and effectively and enrich and equip your knowledge, if you're able to use this time which is never available to you to probably qualify in some other manner without actually getting a postgraduate qualification, which is what many of us are doing. So you're able to read up and learn so much. Then when you come out of this, you will be able to deliver quality services. You will be able to get into new horizons. You can touch new businesses, new clients which you have never talked to. And when all those markets come to India, when China, already we are aware that Japan is advised their businesses to relocate from China. Now, obviously, some of these businesses will relocate to India. So every country which relocates and some of those businesses come to India, and then you will have new set of clients, new set of questions which again come up. And therefore, this is probably a phase which should not be a very depressing phase, but should be looked at as an opportunity for learning. And if you're able to wait and then move forward, you will definitely have huge opportunities coming up. So coming back to this disputes in the context of contracts, as I said, there'll be enough number of decisions on this topic. Each contract clause will be debated. Going forward, drafting of contracts will become a huge challenge. Every lawyer will now become Sashi Tharoor in many ways. They would find as much terminology as possible to fit into force majeure, read all the case laws to see what all is left out and visualize something and put that for all, if they will add word biological war and things like that, assuming certain things happen in the future. Who knows? I have got certain ideas which of course I can't discuss here, but my clause is also going to be quite wide. So force majeure will definitely be differently structured as far as contracts is concerned. There'll be a lot of attention to contract clauses than before. People won't generally do a cut and paste. People will carefully talk and negotiate because it is important. They'll realize the importance of contracts because of COVID. They'll realize not having a force majeure clause, what can happen. They'll realize that absence of a very good clause, how they've lost out significantly. So therefore, future people become more smarter and efficient in terms of their business dealings. And all the old maxims will come down, will come back. And then I also expect that the arbitration scene will go up in a very big way, because if two people are in trouble, then both are in financial trouble. The only route possible is to settle through disputes and dispute mechanism. And if the contract has an arbitration clause, you'll have to necessarily go to the arbitration. If the contract does not have an arbitration clause, you have to go to the courts. And then you will have a third party. What happens if LC has been issued? What happens if bank guarantee has been issued? I may have a contractual relationship where I may have something. but the bank has already got this LC. He may comply with this requirement. So how do I stop that? So if I go to court, will I get relief? If you look at a recent Bombay High Court judgment, somebody filed a petition before the court and sought relief by saying that the bank should be restrained from making payments in respect of a steel import, which I've ordered, and my business is affected because I cannot carry on business in steel because of COVID. The High Court said that your force majeure clause was inadequate. The clause that you had was only one-sided, it was not double, it was not covering both sides. And secondly, they said that steel has been identified as an essential commodity, and therefore nothing prevents you from selling the steel. And therefore, just because it is difficult at this market, you cannot say force majeure is applicable or Section 56 is applicable. So you already have a live judgment of the Bombay High Court on this very same issue post-COVID, which is explained and gone depth into some of these clauses. So you'll have such decisions coming from high courts as we move forward. And I'm not. There's also a possibility that at one point of time, government might decide that just like how we have special tax tribunals, we'll have a COVID tribunal, whereby they would create a special tribunal which will decide all COVID-related disputes, contractual disputes, so that one set of decisions are coming instead of having multiple views coming from different courts. Who knows? Anything can happen. Or even the Supreme Court might pass an order, an elaborate order explaining when COVID can be used as relief under contract law, when it cannot be used. We never know. Those things can also happen. So I would say that going forward, there are very interesting times ahead in terms of the legal field. In terms of the professional, as I said, the opportunities are galore. And since so Sundarajan was kind enough to admit that he is also into 30 years of practice, and I am also into 30 years of practice, which is true. I'll be hitting 30 years in August. So I think that with 3 decades, you can take the liberty of giving some advice. So to the younger professionals who are sitting in this audience, who are listening to this, my advice is you are probably going to benefit in terms of knowledge than ever in your life. Just look out for all these sessions till they happen. Who knows when Zoom gets banned? We don't know. But till it is on, till all these are happening, please look out for all interesting sessions in any topic. Just keep listening and absorb as much as you can, because this is something like you never got. You, instead of reading something and learning, you have experts coming in and explaining certain concepts. You're going to, if you're able to capitalize it, it will only enrich your profession. So that is as far as the slides are concerned. I finished a bit early since there are significant questions that are on. And as we move forward, I will take the questions live as it comes on the chat table. I would once again formally thank the 4 associations for coming together and thinking of a topic like this, because COVID legal issues is something interesting. We always discuss tax, but we never looked at the business and legal angle. So it was a very wonderful initiative, and I'm glad I could share some of my thoughts. Thank you very much for a very, very patient hearing.
Thank you, Vaiti. Definitely, it was an eloquent session, as usual. And simple words like difficulty, simple word like a frustration, and simple play like an impossibility is going to create a huge problem for understanding. This is what is the subject matter of the entire content. But truly, I'm 100% sure that the audience is definitely enriched by the concepts which you have been explaining to the people. There are around few questions, and also there are certain questions that has been put on chat. I think, Amit, are you ready with the questions?
Yes, sir. Thank you very much.
So before proceeding with the questions, let me definitely explain the members that in case your questions have not been put on chat, I think you will be able to raise your fingers so that Amit Nahar, administrator, can include into that.
Yes, sir. Thank you very much, sir. And we're truly honored and glad that you combined both of you. I think we have almost 60 years of experience, sir. I think we're truly blessed to have both of you on the panel today. Thank you very much, sir. So the first, is it okay if I can start with the questions, Vaidishwaran, sir?
Yes, please, go ahead.
Yes, sir. So the first question is by CA Murali Krishnaswamy. And
Mr. Vaiti, you can click the Q&A session. You might be able to read the question on that on the screen. Oh. You can hit the Q&A session.
Yes, sir. So there's a quick Q&A tab just right there, sir. The question is the impact of GST on waiver of rental and equipment leases.
Okay, I understood the question. So let us say that there is a contract or an agreement where rent is payable to the lessor or the landlord, as the case may be. And the lessor and the landlord are kind enough to say that the next 3 months I will waive the rent. You do not pay the rent. Now, when a person waives some money that is due to him, that is as good as the contractual consideration getting altered. So if you're entitled to revenue for 12 months and you've chosen to say, I will accept revenue for 9 months, that is as good as the consideration getting completely altered. So if consideration is getting completely altered, what is reflected in the table is that there's only 9 months of rent that is payable. And on the 9 months of rent, GST is being paid. On the 3 months, there is no receipt of consideration, nor is a requirement to pay. Contractually, both parties have agreed. It is as good as the contract getting modified. Only thing is you have to document this. If there is a waiver, please ensure that adequate documents are there in place to record this waiver. So at a later point of time, there is no issue in terms of taxation. Nobody can deem that a consideration is GST is still to be paid. You cannot impute a deemed consideration in this kind of scenario if that is the concern.
Thank you, sir. And in case members have any counter questions, you could please raise your hand so that I can unmute you. If any member has any counter questions or wish to ask any oral questions, then you could just raise your hand. There's an option of raising your hand as a reaction, and I can allow you to talk. Yes, sir. So the next question is from Mr. Pramod Patni, and it says that in the acts listed for extension, FEMA not included. Whether timelines falling in between for any actions under FEMA, such as filing appeal under Section 17, with special directors FEMA would also face the same fate, or it may depend on the discretion of the officer concerned.
See, as far as you're right, in the sense that, as I made my point earlier, the ordinance did not cover many legislations, and it covered only specific items. But if you look at IBC, relaxation came through IBC itself. If you look at Companies Act, relaxation came through MCA. If you look at RERA, the RERA authorities issued some relaxation. So ideally, RBI should have issued this relaxation. But in case RBI has not issued these kind of guidelines in terms of FEMA, nothing to worry. The Supreme Court decision which I referred to, where the orders were passed under Article 142, read with 141, is absolutely wide. And therefore, if you read that part of the judgment, it says whether that act provides for condonation or not, whether it provides for a delay period or not, anything which is after 15th March 2020, anything which is a due date will stand automatically extended till such further orders are passed. And this Supreme Court decision is the law of the land, and therefore, even if there are no specific directions from under FEMA, you can use the Supreme Court judgment to take the protection.
Thank you, sir. So we have one of our members.
Amit,
yes,
Amit,
yes, sir.
it seems your voice is not clear to the public. That's what Ramnath has said, that if you can slightly adjust your audio or whatever, because there's an echo which is coming.
Okay, sir. Yeah, I think this should be better, sir. So we have one of the members, CAG Narsimulu. He has a question, sir. I'm just allowing him to talk. Yes, sir, CAG Narsimulu, sir. You can now speak, sir.
Amit, your mic is not clear.
Kishore, can you just step in?
Yeah, I can. Yeah, yes, sir. Yes, sir. I'll read the question. This question is from Uttam Chand Jain.
No. Before that, G. Narasimhala wanted to raise a question.
Okay.
Mr. G. Narasimhala, you can pose if it's open. Amit, have you unmuted him?
Yes, sir. I think there is some difficulty in enabling him to speak out. Anyway, sir, I think we can just, sir, maybe if you can, G. Narasimhala, sir, if you can just post the question in the chat, we'll just take it up, sir.
Okay, type the question so it comes in chat, because we're not able to hear your voice.
Yes, sir. Yes, sir. So the next question is from Uttam Chandji Jain, sir. So there is a notification under EPS and ESI giving grace period. So we'd like to know the implication under the Income Tax Act.
This is a very wide question. Are you talking about disallowance? If Uttam is talking about disallowance in terms of reduction claims under the Income Tax Act, and that should be done, because if the law, the due date is virtually extended there, then it applies everywhere. So I don't see a problem there.
So Uttam has made us yes, sir. But obviously, the 43B provision itself says like that only, where that is within the time limit as specified by the respective laws.
When extended there, it is extended for.
Yes, sir. So the next question is from Shraddha. Most of the rental agreement has post major clause. whether any tenant can invoke the clause in this pandemic for non-payment of rent during the lockdown period when the office premise is actually not being used.
See, this question raised by Sarada is that which everybody is raising. In fact, day in, day out, I'm getting this question from some of the clients in terms of clauses. I'm seeing two things. One, the lease agreement force majeure clause is not very well worded in most cases. In most of the cases, the lease agreement force majeure clause says that if the property which is the subject matter of lease is destroyed, or it is damaged significantly, or is affected in such a manner that it's incapable of being used, then the force majeure clause steps in. Now, none of those three words may be enough to rope in a COVID kind of a scenario. So you need to be very, very careful about your force majeure clause. But using the various government orders, which has actually prevented you from accessing the office premises, which has actually prevented you from stepping out into the roads, which has actually prevented the office from opening it. And opening it would by itself would cause a breach of law resulting in a closure. Those events will have to be identified to interpret that I am no longer in a position to use at all. Second list, you also have to see section 108 of the Transfer of Property Act, and that also talks about leases and consequences in that. As I said earlier, it may be more difficult to get out of a lease on account of COVID, but it may be easier to seek a suspension of the rental obligations or some kind of relief as far as rental obligations are concerned. In fact, some of the bigger players in the rental businesses have been very nice and indulgent as far as this period is concerned. They're trying to give some kind of relief. But there are also the situations where they're also struggling in terms of cash flows, or they have invested by borrowing funds to construct this property. It's a new property, yet to realize monies. So all kinds of issues are there. So it will be very difficult to straight away say that I will invoke this clause and I will stop payment of rent. You have to see the scope of the clause as well as your inability to pay.
Yes, thank you, sir. I think I've unmuted G. Narasimha, sir.
Yeah. Can I?
Yeah, please go ahead.
Sir, you are able to hear?
Yeah,
Yes,
I
please
can
go
hear
ahead.
you, sir. Please go ahead.
Yeah. Bombay High Court judgment, you said, what are the things can be included in the contract so that the steel companies things can be overcome in future?
We later on you can message me in WhatsApp. I'll share you the judgment. But the force majeure clause was badly drafted because the force majeure clause in that particular agreement was completely in favor of the supplier and not for the distributor in India. And that is a case today. See, when you see, as a lawyer, I can tell you, when we draft contracts, or basically when we negotiate and draft contracts, it is not a very simple process. Because what happens is each party takes their own positions, and each clause gets negotiated. There are times when para-wise negotiation goes for a few days. So I'm talking about bigger contracts in terms of two bigger players sitting and trying to negotiate something, or new counsel very negative. But what happens in those normal, ordinary transactions of a supply, it is like a distributor agreement. A distributor agreement with a foreign company, you have to be very careful when you draft it. Many people don't realize the risk that is involved in a distributor agreement. How LC has to. So you
Sir, I have.
Yes, sir.
Yeah, this regarding medical equipment and medical pharmacy supplies also, they can delay the payment for other medical equipments apart from COVID urgent medical equipments. Is that something to circumvent that thing? Anything can be done?
I'm not able to follow your question.
Sir, a supplier supplied medical equipments.
Mhm.
The payment for non-essential medical equipments will be delayed on account of COVID priority. That type of situation, how to overcome
No, you see,
contract in future?
in future, your contract terms will definitely have to cover all these kinds of situation, and probably people will even talk about cash flow as pressures or delay in payment, etc. But unlikely those contracts will get executed. The other part, fundamentally, every contracting party will want payment, and they will say a delayed payment beyond a particular date will be the clause, will be used as a weapon for breach of contract, will be used for breach and termination. So even though we may talk about it and say we'll cover all kinds of clauses in force majeure, let me tell you practically, the other side will not agree for a very wide force majeure clause or a very wide payment exclusion clause. Somewhere we'll have to strike a via media in between and then look at it. Or for example, in your case, you're saying that non-essential medical equipments I'm not able to pay because of a problem. Now here, if you look at the Bombay High Court, they said that steel has been declared as essential and therefore nothing prevented you from dealing with it. Now there you get some kind of clue that if something is non-essential and you're not able to deal with it, maybe I can use that as an argument. So we'll have to see each facts and then see how you can build this.
Thank you very much, sir. Thank you.
Vaiti, you will have to stay in the same position because once you come nearer to the camera, people are not able to see you fully.
Oh, okay. Lockdown.
Yeah, impossibility of visibility. Go ahead, Mr.
Yes, sir. So I just complete the questions on the chat box first, and I can see some members having their hands raised. So let me just come in a sequence, sir. I'll just complete the
somebody is looking at YouTube also. Questions?
Yeah,
YouTube?
I'm doing it, sir. I'm doing it. I'll just finish these and then get to the YouTube.
Okay.
Sir. So yes, sir. So another question posed by Sabda is when there is a special ordinance under new section 168A, which gives overall due date extension to 30th June, if a taxpayer has not filed returns within the extended due date, whether he can get coverage under section 168. Please note, for taxpayers with turnover more than 5 crores, there is no extension of due date of filing 3B. Only interest waiver of 15 days delay is given. Whether the interpretation of law that gives specific prevails over general would be applicable in this case.
See, if you ask me, I'm not very comfortable with the existing system, which combines due dates and payment dates. In an ideal situation, GST law must be, even without the COVID, ideally GST must have 2 dates, one for payment and one for return. The linking of these 2 dates creates a crisis. Now let us take a situation where, forget COVID, even before COVID, why did somebody delay his return? It is not as if he is simply lethargic, or it is not as if his charter account is too busy and therefore is not able to file it. Those were not the reasons. The reason was he did not have money to pay the tax. And what are we talking about? We're talking about, let us say, 50,000 to pay as cash. And he does not have that 50,000 to pay as cash. And he used his input tax credit. And after input tax credit, still 50,000 is due. He's delaying as much as possible till he gets that 50,000 to pay. Now, for a person who's not able to get that 50,000 and pay the tax and file the return, that month he does not file. Next month also he's not able to get money, he does not file. 2 months continuously he does not file, there are some consequences. He's not able to generate email and things like that. So it becomes a vicious cycle. That is why my view is that we must de-link the filing of return and the due date for payment. Keep a due date for payment and take action separately, but allow the business to run in terms of filing of returns. With this background, if you look at what the ordinance did, the ordinance actually delegated the powers. 168A identified what could be a calamity, what could be a force majeure, and also talked about the epidemic, and then said that it gave the power, delegate the power to issue relevant notifications to extend to whatever you want. Now, the question is whether the notification issued under these 168A has gone beyond 168A. If the language of 168A is only to extend the due dates, and the notification has actually not extended the due dates but only provided a window of interest, etc., then you have a case. You have a case to argue that the exercise of powers is beyond the notification has gone beyond the powers conferred by 168A. That is one aspect of the situation. The second aspect of the situation is that it is still not everything is not closed, curtains are not closed. Even now, every institute, every association, every business chamber, everybody should represent to the government and say that you cannot collect 9% interest when people are suffering in terms of cash. Whatever is their sales is going to be very limited, and on one side you have to pay employees, on one side you have to examine, they have to pay rents, and one side you are also asking for interest that cannot be fair in terms of equity. And therefore, why not in one stroke say that the return can be filed by this cutoff date without any impact of interest, etc. I think we could still represent and seek modifications for that notification.
Thank you, sir. The next question is from ACA, Adesh. His question is, sir, in accordance with the legislations falling due 23 stands extended to 36, we have initiated a process of conversion of a private limited company to LLP on 21st of March. In normal course of time, the conversion would have happened before 31st of March. But due to lockdown, the conversion has not happened and in process. Now, as per the IT Act, we are facing a challenge of having to pay capital gain tax on shares held by shareholders and also have a piece of land which will attract capital gain tax after conversion. So, will the above legislation come to our rescue?
We'll have to interpret in depth. I won't take this question as an offhand answer, but definitely it is there is some scope for interpretation. The PPT is only a slightly analyzed version of the actual text. So based on the actual text of the ordinance, we'll have to interpret as to if a statement is referred to, if a report is referred to, if some kind of compliance is referred to, is it wide enough to cover everything else? But does it mean that it alters the financial year also can also be a question. But let's look at it from their perspective. When you have a specific section in the term of section 54 to something else, where they say all these due dates go. There were some people asking question whether Form 10 filing for charitable trust has been extended. So we have to interpret that the statement or a report would automatically cover Form 10. You have to start interpreting as to what all gets covered in that wide language that is used, because that is the only way. Because the intention of the law is not to confine the relief only to one or two items. The intention of the law is to ensure that the difficulty arising out of COVID in terms of compliance requirements is arrested, and whatever due date that is there in terms of compliance is deferred. So it is not as if it is a selective gift that is given, that only certain transactions are covered and certain transactions in the Income Tax Act are not covered. I would not interpret that way. A harmonious interpretation would cover every single requirement under the Income Tax Act. But as I said, we'll have to go deeper and give you an answer.
Next question is from Mr. Balaji NB. His question is in relation to the waiver of rental, sir. So whether such waiver of rent is application of income or overriding title.
But trust Balaji to ask that question.
Nobody else can.
See, let's look at some of our earlier principles on diversion of title by diversion by overriding title. We had the very famous case law in those days where a businessman collected one particular amount for charity or dharmada, as we call it. So as he makes a sale of 100 rupees, 1 rupee was straightaway allocated towards charity. And then it was argued that this money was not belonging to me. It was completely diverted by overriding title. So diverted by overriding title indicates that this money is not belonging to me. Somebody has got a title over it. Now, in the case of a waiver of rent, there is no third party who's got a title over the rent that is paid. The landlord is required to claim so much of rent from the tenant, and he decides to waive a certain period of rental or a certain amount of rental. It doesn't mean that somebody has got a right to claim this as his money, or this money goes to that purpose, or the landlord is collecting and sending it. Now, let us imagine a situation where the landlord redrafts the contract and say that whatever rent collected for next 2 months has to mandatorily go to PM's care fund. If something like that is structured, then we may probably say it is diversion of overriding title and going forward. I would not see it as application or otherwise, but whether this waiver of this 2 months is still income or not can be a debate by itself. We'll have to go deeper in terms of precedents to analyze it, whether this would still constitute income, given the fact it is income or host property.
Yes, sir. Next question is on EMI payment that you had mentioned. FM will not apply to payment. How will this be different in case of rental payment?
How will this be different in the case of rental payment? It is not. It won't make a difference. But the difference is that in a rental kind of an arrangement, I've seen some force majeure clauses which kind of allows a suspension in case certain events are not done. For example, let us say that an agreement is signed where a mall is saying that we'll make the property ready for you, and you will have to take the property on rent or license. You'll have to start paying monthly so and so fee, and then you'll have to put up your fit outs by so and so date, and you'll have to become live by so and so date. So this is the agreement. Now the site has to be made ready and made available by the landlord to their tenant for putting the fit outs. Now, assuming because of COVID, the landlord is not in a position to make that site ready and give it for fit outs. And in that case, there is some kind of a mandatory lock-in period. Let us say there is a 3-year lock-in period. And this 3-year lock-in period kicks off from the date when the site was handed over. Now you have a very clear bargaining chip to say that you have not given the property, you have not made available the location. How would I start the fit outs? Without starting the fit outs, I cannot start my rental of my site, my building, my outlet, and therefore I can't pay the rent. So those are the kind of interventions that can flow through, depending again on your force majeure clause, in terms of the site handing over date, in terms of the fit out period, in terms of the lock-in period.
The next question is from CAG Narsimlu.
That is over, sir. He has spoken.
All right, sir. Perfect. Thank you. The next question is from CA Tarun Kumar S. If the force majeure clause is not in the rental agreement, still waiver can be claimed for rental. Still waiver can be claimed for rental.
See, it won't become a right, but it can be a relief which parties can negotiate. See, it all depends on what kind of relationship the parties are having. If it's a very healthy, long-standing landlord-tenant relationship, there is every possibility the landlord may also give the relief. In fact, there are scenarios where the tenants are also calling upon the landlord to ask for future discounts. So imagine a situation where your rental agreement talks about an escalation clause which kicks in next year at 15%. You will obviously want to amend the contract. You will probably want to get into some kind of supplementary agreement to modify the terms. Everything is possible because going forward, everybody is going to face some kind of financial crunch. And if that is the case, then they would look at renegotiating all their obligations. So if there is a costly arrangement, they may even look at getting out of the costly arrangement. If there is some payment you made and they get out of it, they may get out of that. So even landlords will be aware that they may not get future tenants. And therefore, an existing tenant is as good as a good tenant compared to a possibility of your property getting locked, because new business are unlikely to happen so quickly. And as I said, the rental demands can completely change. So instead of making it as a right or a claim, if it can be talked and negotiated in a very friendly manner, you'll be surprised that you may get better results.
Yes. Next question is from CA BMV Subarao. Whether the due date for filing monthly ECB returns have been extended or not?
Monthly?
ECB returns. ECB.
What is it?
ECB, external commercial borrowings. Basically, FEMA has not been included.
Again, FEMA. So you have to look at a specific notification in
Reserve Bank of India.
If it is not there, ask for it, you will get it. Because every authority is issuing it. Because in fact, Competition Commission has not issued still now. RERA took some time before, but RERA also issued all the, Tamil Nadu at least was very fast, they gave all the orders. So if you represent, you will get immediately relief. It is ideal that you flag it in case there are no specific notification. Don't wait for interpretation. Don't try to interpret based on all these things. You may actually get much better relief by asking for it.
தட்டுங்கள் திறக்கப்படும் கேளுங்கள் கொடுக்கப்படும்.
Yes, this time, yes.
This question is from CA ANL Madhavan. ANL Madhavan. So whether Lex doctrine applicable for notices issued by agency or courts or even enforcement directorate, etc.
See, an enforcement directorate, where is he operating from? Or if you take a DGCI or DGGAI, where do the powers come from? These powers come from these legislations. So any notice that is coming in from any of these authorities, if you trace back their source of power, it will flow from any of these acts, especially these tax acts and tax related acts. But if you're looking at some kind of a CBI investigation or some other investigation which is outside these kind of legislations, you may just have to reply saying that I'm not able to come out. Anyway, I'm still in lock. I'm also in the house, so therefore there is no necessity for an arrest separately.
In fact, similar thing happens, Vaiti, in respect of cases handled by faced by chartered accountants from the Institute Directorate itself. Now they have sent a letter saying that because of this, your discussion is being posted subsequently. In case it doesn't happen, it is expected that automatically it is getting extended. We are only advising the customers who are affected by that to send a email saying that because of this, they are not able to access the legal remedy.
Correct. Proactively, as you said, it is better to give a communication than assume that it's going to be automatically extended.
Exactly.
So this question is from Mr. Murli, sir. You touched upon the government orders, advisories of government on wages or salary payments. Would the government come out with some package for SMEs by way of grants or soft loans? This is a suggestion. What's your view?
I'm sure the government is thinking on something. See, I will put it this way. I could be wrong, and I hope I'm wrong. I have a feeling that this is bigger than what we think. And the government is equally aware that this is not something which is short term, and this is going to be a very long term affair. And therefore, government is also probably holding back its purse, because you don't want to completely let go. And then you find that you are not even having any kind of resource when it becomes even more critical. Now, today you are in a stage where you can manage. To some extent, you can manage. Somebody is helping, somebody is moving certain things. You're still in the manageable stage. So what is the government's focus? The government's focus is to ensure that the poorest of poor don't get affected. So they have ensured that food goes to the poorest of poor. So that is taken care of. Then the next level is the employee. So they've tried to say that don't stop the wages, don't continue to make the wages, make the payment. Of course, I have doubts as to the legality of some of the orders under the National Disaster Management Act, but still, suffice to say that orders which says you have to do certain things. But is it easy for the government to open and give a very big stimulus? I have my doubts. So what will happen is that they will slowly release version 2, version 3, etc., depending on the situation. Because we don't know. Let's look at Singapore. Singapore was a country which we thought had completely come out of Corona. And they were completely saying that we are back to normal. Everybody follows social distancing. Everybody wears a mask. Work is as usual. And then suddenly they were forced to go on a lockdown. And last 3 days, the cases have simply jumped up. And 2 days ago, Wuhan released some kind of data saying that our data was 50% wrong, which is much more than, the deaths were much more than what we said. So therefore, I'm sure the powers that be are fully aware of the bigger, longer run that is going to be there as far as this COVID is concerned, and are clear that they're probably looking at it as a war strategy and planning certain installments. So I don't think that immediately some major fiscal package would come, but SMEs would definitely get some kind of relief, because they are going to be hit. They're the most vulnerable after the poorest of poor, because they don't have buyers, they don't have sources of funds. Similarly, the urban poor as well as a middle class employee is also going to be stuck in a very big way. And somewhere something would have come, some kind of relief would have come at that point. But I'm sure that the government is toying at various options in terms of how this can be attacked, because they have to look at from a health perspective, they look at from an economic perspective. You can't just like that to open an economy, because business has to run and people have to get into employment. What happens if because of people running into an organization something happens? We had instances of this happening in the judicial magistrate courts, and then you had some kind of quarantining happening. So it's not easy for anybody to take a decision at this point of time, and therefore I'm sure government has got its own way of dealing with fiscal packages and stimulus packages, but they are definitely looking for a long run battle.
Thank you, sir. So this question comes from Mr. Rajesh Kumar. His question is: some companies are in the process of pay cut. What will be the consequence from the contest of the employees, from the employer?
I'm sorry, I'm not able to hear that.
Some companies are in the process of pay cut. What will be pay cuts? And so what will be the consequence from the contest of the employer? I'm not sure if it is employer.
Context. Amit, that is context of the employer.
Yes.
On similar line, we had, one second, Vaiti. On similar line, there are other questions also which has been queued up by somebody else also. There are situations in an organization where they are not working. Let us talk about manufacturing companies itself, which are allowed to be worked from 20th onwards. Even after 20th, staff may not be able to come and join. In that situation, there are 3 situations: whether no work, no pay, or as per the government's law, we have to pay, and to what extent we have to pay, whether there is a cut which is required. Central government itself is saying that every central government employee one day salary will be cut. That is what the announcement which has happened today. So similar to this, some companies are in the process of pay cut. What will be the consequences from the context of the employer? This is what the question. So
I got the question, and to some extent, one of my slides I talked about it. I'll just explain it since the question has been asked again. See, unlike UK government has implemented what is called as a furlough policy. And in a furlough policy, what happens is that the employee and the employee together come to an arrangement or an agreement whereby the employee says, look, I will stay home on furlough. I will not come for the next few months, as you say. How much ever months you say I won't come, I will not attend office. The employee would receive 80% of his pay, wages or salary. That means there's a 20% cut. And for making this 80% payment, obviously the employer, as you say, does not have revenue, it does not have sales, and therefore the government steps in through a scheme. And the government monitors whether the money given to the employer goes to that employee who's on furlough. An employee who's on furlough cannot work for that employer in the back end. It is illegal to make that employee work for the employer because he's on furlough as far as his payment is concerned. He can work for other employees if he wants, or he can do something as his self-skills he can deploy. But we don't have that kind of a system, nor is it easy to implement such kind of a system.
Possible.
Because we are already running in a deficit budget. How much can the government step in and provide? So on coming to the legality of that, it is very difficult to get into this debate, and it is not fair. I'm not a labor lawyer, but suffice to say that my reading of the laws as it stood before and as I've read from memory, whether that kind of power is available in the National Disaster Management Act is a question. National Disaster Management is definitely a very powerful legislation, but can an order be issued under that particular act mandating payment of salaries and wages? And can you mandate something when it is otherwise impossible for somebody to pay? That can be a question. Given the fact that for labor law, you already have an Industrial Disputes Act. You already have a layoff provisions under those acts. You already have retrenchment mechanism in those acts. You have layoff, which allows calculation of wages, 50%, etc. Period. Everything is stipulated. So is it not a special act? With the employment-employee relationship is not specially governed by these labor laws. And whether the regulation, the notification has gone beyond what is contemplated in that particular disaster act is definitely it will be a matter of debate. And as I said earlier, the Supreme Court has already seized the matter as far as the journalist union is concerned. The journalist union has filed a petition before the Supreme Court in the context of some of the newspapers and digital media bringing in pay cuts and sacking people. And that they have referred to the Home Ministry notification dated advisory dated 20 months in terms of arguing for their case. We have to see what the Supreme Court says. But coming to pay cuts, now, and it is always a matter of relationship which always prevails. In fact, in abroad, what happens is very easy, because the chairman gives a talk saying that, look, our business is getting affected. We are likely to close 2 months' time unless you go for a 40% pay cut. And everybody agrees to go for a 40% pay cut or a 30% pay cut, etc. So we may have to look at some kind of innovative system where it has to be an agreed process between the employee and the employer. And there must be some cutoff that this kind of employees, let us say somebody who's getting 15,000 or 20,000 salary, no kind of pay cut, because what will you do if you cut that itself? So beyond that, there can be a graded pay cut. Higher level executives can take a pay cut. Senior persons can take a bigger pay cut. So some kind of solutions will have to work, because as you rightly said, if I don't sell, I don't have revenue. If I don't have revenue, I don't have cash flow. Where will I go and pay? And who will lend me money to pay this? Nobody's going to lend me at this point of time. So you can't enforce something which is actually impossible. So for all you know, the principles of impossible will be applied here at some point if some kind of compulsion comes.
In fact, ICA, once again, Amit, in case ICA, they have categorically said that the period of this close down will not be considered as leave for the students. But as far as the stipend is concerned, it is for the principal and the students to come to an agreement and decide on that. I'm talking on the smaller side. So effectively, the same similar thing has to happen in respect of the employer-employee relationship also.
Definitely. And it will affect even professionals. It is for the manufacturer.
Yeah.
Very big CA firm which has got number of people, or a law firm which has got number of persons.
True.
You will also face the same kind of financial pressures.
Correct.
Thank you.
Amit, go ahead.
This question is from Mr. Palniappan A. The original VSV scheme did not have any payment terms post 30th BSV scheme, sir. The press release, BSV scheme.
What is that?
So I
Schemes, sir,
request, I request Palniappan sir to please.
Oh no, Vivad Samadhan scheme.
Yeah,
Okay.
Vivad.
Oh, okay.
All right.
BSP. Okay, I heard it's BSP.
BSV, sir. Yeah, so the press release said any payment post 30th June would be at 110% of the tax. But the scheme as enacted mentioned that the scheme is valid only till 30th June. Should I repeat the question, sir? So
I got the question. I got the question. So what you
he'd
need,
like to know your thoughts.
you just need to look at that ordinance which has come, which I discussed a couple of slides before. That ordinance clearly talks about the scheme. It also talks about the date. It also talks about the extension of the due date. And probably, if required, they would do a further extension. So as of now, they've shifted the date from March to June as a condition for getting payment as per the scheme, and something more than that at 110%. But if things go bad, as I said, the scheme, even to generate funds to make the payment under the scheme is going to be a challenge, because you now have to prioritize payments. See, earlier businesses were prioritizing payments even when sales were there. Even when sales were there, there is a working capital management program where they will decide which will take priority. Now, in this case, you will have to look at the incremental cost. Let us say a business is allowed to open. Let us say April 20th, some industries are identified as allowed to open with 20% employee strength or 30% employee strength. Now, there will be strict guidelines. Now, let us say if you're having 200 employees and you're bringing 40 people inside to work, you will have to implement a completely new system of manufacturing activities. Right from the entrance point, you may have to have checking controls. You may have to have systems in place to ensure that the employee does not come from a containment zone. You'll have to ensure that the employee passes through that thermo test that you have. You may have to get self-declaration from the employee to say that he is not COVID positive or he is not living in a quarantine apartment complex. And you will have to ensure that social distancing is also implemented in the factory, their business where work is carried out. And it may not be easy, because one person may stand to next person, the other person while working. You may have to provide adequate number of masks and sanitizers while people work. While using sanitizers, it can also become a fire hazard in certain foundry operations. So every aspect of your business which you normally undertook will be very, very different when you are carrying out the same operations post-COVID. Because you have to be very careful to ensure that not one person gets an infection. Because one person gets infection, then you may have this end effect of the entire plant getting into a closure. Therefore, you have the running back into operation not going to be easy. Therefore, there is further incremental cost, and nobody is clear as to which is the best solution. One day, people said tunnels are good. Let us have disinfection tunnels. Let's implement people going through tunnels. Then an order passed saying that tunnels are not healthy. It causes other hazards. So it is now everybody is experimenting and trying out new things. So it is going to be a very big challenge in terms of finding funds for going to this Vivad Samadhan scheme and make the entire payment of tax. So my guess is either the due dates will get further extended, or business will take a call. Okay, I will continue with the litigation. Right now, my priorities are different. Let the tax dispute go on.
Vaidhi sir, sorry, just to add further input to your answer, Mr. Palniappan sir, as of now, the closing date of the scheme under VVS has not been notified.
Correct.
30th June is only the date up to which you can pay 100% of the tax. Post 30th June, it is 110%, but the closing date still has not been notified. And today morning, through that ICA seminar, Dr. Girish Ahuja has clarified, they are of the view that the closing date can be 30th September. This is only to give you further input.
Yes, sir. So the next question is from ARN. In case there is force major clause, in case there is no
already
force
covered,
major
sir.
clause.
This is already covered.
Yeah.
So we'll go to the next question, sir. So yes, sir. So from Mr. JP, what is the sanctity of summons which compels presence? Take the case of an accused escaping lockdown by traveling to Mahabaleshwar from Mumbai.
Let us not get into this debate of somebody who's in breach in law. You have a government, you have a clear lockdown order. You're not supposed to step down out of your residence. You're supposed to stay home. You're supposed to respect the law. You're supposed to respect your fellow citizens. You're supposed to ensure that nobody else gets affected. So we will not even discuss those taunts or cases which involve taunt.
So the next question is from CA Tarun Kumar S. Can we claim insurance for business losses arising out of the COVID-19? Insurance covers such fires and accidents, etc.
See, all insurance policies, we're all going back to the same thing which we discussed. Contractual terms matter. And as you would have seen in the presentation, when Suez Canal was closed, the decision was that nobody prevented you from moving the shipment through another route. And therefore it was not accepted as impossibility. We also saw the SARS case in Hong Kong, where they said that lockdown for 2 weeks would not entitle you to say that I won't pay the rent. And therefore, it all depends upon your terms. So if you have an insurance policy and that clearly covers this kind of a peril, then you're covered. But if your policy doesn't cover this peril, then I don't think you can claim relief from the company, because you cannot read more than what you have agreed as far as the contract is concerned.
So this question has come from CA Rajgopalan Sampath sir.
Sundarajan, before you question, I think somewhere I saw Justice Anita had joined. If so, please welcome her.
I see.
If she can flag her hands, Amit can catch that and.
Yes,
Justice Anita Sumant, madam.
Yes, madam. We welcome you to this seminar, madam. We are truly privileged by your presence. If you could just raise your hand, madam, I could invite you as a panelist. So there's a.
I have made, sir. I made a panelist now.
All right. Thank you very much, sir.
Good evening, madam, and for such a wonderful opportunity, the privilege that you are here in this. I wish you had come earlier, because I'd gone through an elaborate presentation on legal issues with reference to COVID from tax as well as contracts.
Thank you very much, Vaiti. In fact, I've been here from minute one, and I've enjoyed every bit of the presentation and found it very interesting as well. I'll go back to being a silent beneficiary of the presentation now.
Oh, so good. So nice of you to be. So thank you very much, madam.
Thank you, madam. So there's this question which is come in the chat box. So by Uttam Chandra Jain.
One question we have missed out in between, I think so. Something by Subbarao, whether GST is payable on rent when force majeure clause is invoked.
See, unlike your income tax, which deals with income from house property, GST is clearly a supply for consideration, and consideration is also defined in the statute. So if the parties are able to renegotiate the consideration and there is a clear waiver of 2 months or 3 months rent, then the consideration is restated as far as contracting parties are concerned. Therefore, you will not have a GST liability. And in case it is a case where you have already raised an invoice for the rent and you have paid the GST on it, and the contract is restructured, then you may have to go through the credit note route to ensure that the tax is adjusted against some subsequent months. You have to follow section 34.
Thank you, Sundarajan sir, for bringing that up.
Yeah.
So this question is on the chat box. It is from Rajkumar sir. So this extension of due dates in case of section 54 to 54F is only for due dates falling during lockdown period, or will it get extended by 40 days as of now, even in cases of due dates falling later, say July to August or September?
No, it is very clear that the due date stands extended up to 30th June or such other date as may be notified. So as on date, your window is extended up to 30th June. If it is beyond, if the government feels that there is some necessity to take further steps in terms of extension, they have kept the power through executive. Therefore, there can be a notification extending the due date.
So that question was by Raj Gopalan Sampath. So the next question that we have is, sir, as a follow-up of the Bombay High Court judgment. Okay, I think we've already seen this. Yes, sir. So this question is from Uttam Chandra Jain. Whether Lex doctrine applicable for notices issued by any agencies or courts? Yeah, we have already seen that.
Already clear, please.
Yeah, since
one question I'll read out.
Please go ahead.
from Mr. Jagannathan Murali, past president. Which one will survive in court of law? Section 56 of Contract Act or a force majeure clause, assuming that it is absent in the contract?
No, no. If you have a force majeure contract, a force majeure clause in the contract, that will definitely prevail. If you read that Energy Watchdog Supreme Court judgment or the Narmada Bachao judgment, there is a clear analysis of a force majeure versus Section 56. So if your contract provides for a force majeure clause, then that there ends the debate. You cannot look into Section 56. But if your contract does not have a force majeure clause, then are you in a position to demonstrate that the second category referred to Section 56 has happened? Is it possible to say that the contract is there, but the performance is impossible? And the impossibility is such that goes to the very object of the contract. If you're able to demonstrate, then 56 should apply. There is also a good Telangana High Court judgment which had analyzed all the decisions on this. I'm not able to recollect that name, but if I come across it, I'll share it in WhatsApp.
Thank you, sir. So there's one question which has come on YouTube Live, sir. This is from CA Kodan Raman Janaki Raman. If the employer deduct 20 or 30% due to COVID, then what about the TDS consequences?
See, the TDS is completely it is based on what you are paying as salary and what you pay as professional fees. Why go to salaries? In fact, so some clients have actually written an email saying that going forward, we request you to take a 30% cut in case you raise bills in the future. So it is not as if it is only going to be employee. Even professionals will get such emails from clients saying that going forward, you may have to take a cut in terms of the fees. And therefore, ultimately, what is paid as fees, what is paid as salary will be relevant for TDS.
All right, sir. I think there are other questions which have mostly been addressed, sir. So I think with that, we come to the end of the questions, sir. So if any other questions, if any member has, if they wish to raise their hands, we're good with that. Yeah, I think Kishore sir has some.
Vaidi sir, one query. Yes, sir. Sir, government has been issuing advisories, various state governments or central governments, that the employer should not send back the employees or should not deduct the salaries. It is called advisory. So what is the legal binding nature of this?
See, first of all, whether it is very clear. Advisories are recommendatory in nature. They don't have a binding force. That is quite clear. But the one that came under the National Disaster Management Act did not look like an advisory. It looked like an order. So that is what is worrying many people rather than the advisory that came from the Ministry of from the Home Department. But as I said earlier, when you have special laws which deal with it, we'll have to see the interplay of these laws. For all you know, matters could land in court, whether which is a special enactment, whether which prevails over. If both are central enactments, which will prevail? Are they different topics? If you remember, sometime we had this dispute in the context of ACA Act versus Customs Act. I know whether export duty can be imposed on goods going out of the country. Therefore, there is an elaborate Madras High Court judgment which discussed when two acts are there and each for a different purpose, you cannot look at any kind of overriding principles. Both will apply in their own ways. So those kind of judgments will also come into play in terms of understanding the scope of the order. But as I said earlier, I'm not a labor law expert, so I shouldn't delve too much into this topic.
Thank you, sir. So that's a wrap on the questions, Mr. Kishore. So I'd like to thank you, sir. I think we've.
Okay, if there are no hands raised by the members, participants anymore, I think we are coming to the conclusion of the program. I recognize the presence of Ms. Anusha Madam, Secretary of Society of Auditors, and also Chairman of EFA, Mr. T.G. Suresh, as an attendee. They have not been part of the panel literally. Thank you very much for being part of the program. I hand over the proceedings to Mr. Kishore for a formal vote of thanks.
Yes, sir. Thank you. Respected friends and delegates, happy evening to one and all. I feel delighted in proposing a vote of thanks for today's program. First of all, let me appreciate the kind gesture of Advocate Sri Vaidiswaran sir, who had consented to become speaker for today. So the session was very good, informative, had lots of inputs for us. In fact, the case laws were moving from 1805 to 2019. And it was from across the globe, like how COVID-19 has encompassed your case laws were from across the globe. That was very good. Sir, on behalf of all the organizations which have joined today for this webinar and on behalf of all the participants, I express my sincere thanks to you, sir. I would also like to recognize the joining of all the delegates which made this program a great success. It's a maiden program. Today I saw total number of participants on the Zoom was about 150 plus, and on the our maiden launch of YouTube, it was 47 plus. And my special thanks to Justice Anita Sumant also, who came as a special appearance for the day. And at the end, I also extend my gratitude to our moderators, CA Bharat Kumar and CA Amit Nahar, who saw to it that the event was conducted seamlessly. Thank you, one and all, sir.
Thank you very much.
Thank you very much.
Thank you.
For coming
Thank you.
first.
Thank you, sir.
Thank
Thank
you.
you, everybody.
Thank you all.